The worst just happened at the Madlanga Commission yesterday. It has now emerged that spies were allegedly planted inside the commission to expose the identities of witnesses to criminal kingpins. Even more shocking is the revelation of who these individuals reportedly are, a discovery that could leave many people stunned. But before we reveal the identities of these individuals, let's first take a moment to watch the emotional moments when several witnesses broke down while speaking about the threats to their lives.
I was sitting with a neighbor who was on the passenger seat, and 3 men came up to the vehicle that I was in. They came there. The one that came around to the driver's seat cocked a firearm and pointed it to me. I had the windows down, and he then demanded that I switch off the vehicle. So he put his hand in to try and reach for the keys on the ignition, but it's not the kind that you start manually with the key, it's those press buttons. And there was a lot of things that was being said. Behind me, as I was on the driver's seat, another came in, and there was this sharp metal object against my neck. Initially, I thought, yes, a knife that's going to slit my throat, only to discover that that is a firearm. And that, I think what hurt me the most with everything that was said at that point, it was then, it is things that are work related. And the fact that, they want a phone from me, and the information which they want, and the fact that they would be, sorry, commissioners. I was hit on the head with a firearm. The accosters shoved me to the side of the passenger seat. They got into the car and they drove off. They drove past my house, and I could see my neighbor who's literally looking inside the vehicle to identify who the drivers are.
Ms. Thepa.
As if we all choose to leave when the stakes got too high. I have been told that this investigation is dangerous and I am going to die. This is true. But if I had to do it all over again, I would. If I had received that call on the 17th April 2024, telling me to go to an active crime scene in Bramley, but if I do my life,
Witness
at risk, I will be in a safe house. I will do it again if I knew that it would make a difference in other people's lives. Even if the safe house options was not in place, I would still do it all over again. I have met the families of the victims.
Conducted at that point. Thank you.
Please then proceed to paragraph 36. Witness C.
Thank you, Commissioners. In the yard or in the premises of Mr. Matlala, there were a lot of vehicles. So now, as I was taking record of all the vehicles that were in the premises, a white Toyota Corolla entered the residence. I indeed went to the driver of the motor vehicle and asked who he was. I identified myself to him, and he told myself that he was given Tsepo Makofane, and he was a driver of Mr. Matlala. He further informed me that he had received a call from Mr. Matlala that he should come and fetch him. And as I was still standing with Mr. Makofane, taking his details, a combat member came to me and advised that my commander was looking for me. I then left with the combat member to the main house, where he directed me to the main bedroom, whereby I found my commander with a person that became known to me as Mr. Matlala, and a person who became known to me as Mrs. Tsakane Matlala. Thank you.
Witness C.
Did you just see that? And it doesn't end there. Now watch the exact moment when another witness burst into tears and mentioned one name that left everyone in the room in total shock.
I am living a shadow of my former life. On the professional front, I am no longer able to execute my duties in the manner I previously did, because I cannot move freely in public without 24-hour protection. It is difficult to meet with informants or to make new connections. As my current condition is not conducive to blending in and meeting people in order to get information, I cannot go to court normally and seek my orders. My movements are not free and spontaneous. On the personal front, I cannot live a normal life. I cannot go to the gym or eat out without risking my life. I have a family that I am deeply committed to, but cannot take my family to a shopping mall or arrange that we go out on a holiday. I rarely see my family because doing so is a direct endangerment of their lives. This has alienated me from my family, in particular my wife, children, who I have not seen in an extended period of time. I bring this to the Commission's attention because it is important for them to know the sacrifice.
Or he would suffer some form of detriment.
So how
and if
do
you
we,
think,
how
if
do we
you
test-
think
how do
the
we
criminal
test-
justice system is so good
So how do
that
we
all
test-
witnesses are safe,
So how do
I
we-
respectfully
how-
request you to read the newspaper.
How do we test then the authenticity of what you are telling us when you do not want to share the sources? Because the sources should be used by this committee as proof.
Because
Under normal circumstances, the sources should be also writing affidavits to say, really, this is what happened. Because now you rely on hearsay evidence, and it's difficult for us to test that hearsay evidence.
Yeah, unfortunately, that is the problem we have in South Africa today, that many witnesses will be murdered if they give evidence. And if I talk, for example, about the Madlanga Commission, we no longer have a witness D and we no longer have a witness F. And it's a matter of time before witness A, B, C, E.
Here comes the final moment we've all been waiting for. Now watch as a witness exposes the names of the alleged spies planted inside the commission, along with the kingpins said to be behind them.
Before today's witness takes the stand, we have an interlocutory application that has been brought by Mr. Suleiman Karim, and it's for his evidence to be provided in camera. and Mr. Premid will address the Commission on that application. And I believe there's a preliminary issue that Mr. Premid would also like to raise with the Commissioners, if we could begin there. Thank you.
I also have a preliminary issue I wish to raise with your preliminary issues, but perhaps let's hear your preliminary.
Thank you, Chair, and for the indulgence of going ahead of you. My learned friend is correct. This is an application that my client's main evidence be given in camera. My concern at the moment is that even though the directive says that it will be given in an open session at the college, as we are here today, my concern is that if the in-camera application is argued in front of all and sundry, and I say that with all due respect, bearing in mind that there are cameras here at the moment, and I don't know whether there is a live stream or a live broadcast, I have to raise the possibility that the very argument of the in-camera application would render the application itself and any subsequent determination nugatory because of the consideration of it being in camera. And I must admit, when I read the original directive that said open session at the college, I assumed that that meant we would have an open session in the way that we are physically here, but that it would still be determined in camera pending whatever outcome is to be made, as opposed to how we had asked for the reasons canvassed the in-camera application, that it be done virtually or at a different venue and so on. And so I just have to register my concern with all due respect that the very substance of the application we're going to debate, which will determine how my client gives evidence, is potentially going to be pointless by virtue of the fact that we may have a live proceeding or live television proceeding that goes out. And may I just say this, I can understand that if the Commission is ultimately against me on the in-camera application, that there can be publication of everything ex post facto, because in that instance there would have been a final substantive determination on whether it should be in camera or not be in camera. But if we argue the in camera in open, as we are doing at the moment, and I repeat my concern about live television proceedings, then that creates the prejudice. And you would recall, Chair, that in the notice of motion filed by the applicant, if you have the paginated bundle in front of you, if you look at paginated bundle 3, prayer 2, the prayer 2 notice of motion, with all due respect, I think covers a situation that we find ourselves in where the very request for that proceeding itself is to be in camera. Otherwise, it would be, the outcome would be rendered nugatory. And so those are my submissions as to my preliminary concern. Thank you, Chair.
Thank you, Mr. Premid. Mr. Premid, I'm not sure that I follow you with regard to the point that the outcome and what's basically sought will be rendered nugatory. I just don't get that, because what Mr. Karim seeks is that the hearing of his evidence should be in camera.
Yes.
If he succeeds, how will this open session have rendered that nugatory?
Well, that's the exact dilemma, Chair, with all due...
And also, perhaps, let me add this.
Yes.
All, if I'm not mistaken, my colleagues will correct me, and perhaps even the evidence leaders, all applications for in-camera hearings have always been heard here in open session. And a good few of those were found to have substance, and the actual hearing of the testimony was then in camera.
Yes.
So I don't know what makes this one stand out, and for the argument that the whole thing will be rendered nugatory. I just don't follow it. I just don't follow it.
I followed the question. If I may respond, Chair. On the first issue about defeat the main hearing, what you will, and now I speak with some hesitation because I'm now traversing potentially some of the merits of the in-camera application, and we're not yet at that stage. We're determining rules of engagement, if I can put it that way. What you will know is one of the arguments that is made in the in-camera is that my client started receiving death threats, and that those death threats emanated even before he gave his actual evidence at the commission itself. And so my client's position is that he is being subjected to those death threats regardless of the actual evidence he is going to give. Now, the fact that we are having this debate about whether he should then still give that evidence in camera or not in camera now reveals to the public at large watching in that he's been the subject of those death threats and that he might be made to give evidence, but it just will happen on a day or in a time or in a format that the public at large might not know about. But the concept of that doesn't detract from the client on what he says in the affidavits is that he's being surveilled. And the fact now that this has already happened on live television, with all due respect, does undermine the very purpose of the in-camera, which was to protect that disclosure when he comes back to the commission to give his evidence in chief, if I can call it that. And because of the particular situation that my client finds himself in, the fact that we're already publicizing the fact that he's making the in-camera application is the prejudice that we are talking about. So that's on the first point, if I may, Chair. On the second point, I obviously can't answer for what other applicants did in respect of their in-camera application or whatever the case might be. I'm not privy to that. But on the facts of this case, and because of that surveillance which I've just mentioned, that's why a particular prayer was included in the notice of motion, prayer 2, that the actual argument of the in-camera be held in camera itself. And again, I say this without trying to traverse the merits of the in-camera application, but I'm just registering the difficult position now that my client is in, because the surveillance which happened from the previous session is now going to continue, arguably, from this moment in time, because if my client doesn't appear to the public's knowledge on the 9th and 10th, the public will know that he's compelled to give evidence. It's arguable that the in-camera was granted, and that he's still giving evidence with the effect that the threats are going to materialize again, with all respect, because effectively now has given publication to the very concern that my client had, that he's under surveillance.
So, Mr. Karim, wants the public to be under the impression that he will not be testifying, or exactly
no,
that's the point?
That's
what then is the point?
No,
because if the public or even those threatening him are aware that he will testify at some point, what difference does any of this make?
The difference is, Chairperson, in the two alternative factual scenarios is, let's assume when we came in here this morning, this session was being conducted in camera, in the way that I had understood it would be. What that would mean, with all due respect, is that there would be no insight given to the people outside of this room that the in-camera application was made. And if it was granted, then the public knows that Mr. Karim ought to have testified on the 9th and the 10th. That might not have materialized on the...
Even those threatening him will be under that same
Agreed.
impression.
Agreed.
So what's the difference?
I was getting to that, if I can finish.
Yes.
What I was saying is that in the scenario that I'm talking about, that if these things were in camera, on the 9th and 10th, if the commission is with me and grants the in-camera substance, then whoever is threatening Mr. Karim and the public at large will have to speculate, why didn't he give the evidence? Is he still giving evidence? Or whatever the case might be.
That bundle is not ready. You will move mountains for it to be served today.
The bundle will be provided today.
Thank you. Thank you. Mr. Premhit, you, quite early on, you made a, maybe let me start right at the end. I'm not sure that I follow your submission on the relevance of what you referred to as head notes on prejudice to the determination of the in-camera application. I'm not sure what the relevance of those head notes is exactly. You did explain it, but I still remain in the dark as to what you suggest the relevance is.
May I respond? Thank you, Chair. No, I accept what you say to me. What I am using those particular examples of is, in each instance of those examples, my client has asked for a reasonable accommodation, which has been refused. The response to that has then been that my client has to, through its legal representatives, litigate quite aggressively, whether in court or in front of the Commission, with interlocutory applications, to have that reasonable request, firstly, reasonably considered and then decided. And I was linking that pattern of conduct to the opposition that is being put up here, and I explicitly detailed those grounds of opposition, the publicity, the fact that it's already known, but importantly, there's no counter-argument as to the credibility of the threats, that in those circumstances, the Commission insisting that my client be made to give the evidence in an open session where those threats are highlighted for determination is a further instance of the prejudice that my client finds himself in. That's the extent I was using it.
I trust, though, that the suggestion is not that the in-camera application will not be decided on its merits.
No, not at all. I know for a fact it will be decided on its merits.
I just wanted to be sure in my mind what exactly you mean by that.
In fact, Chair, if I may, I think the way you've put it to me crystallizes the exact point. It's that in each of those instances that I've spoken about, my client, to use your phrase, has had to move mountains to try and clarify his position and get certainty and outcome. And this in-camera application is yet another example of that, in circumstances where my client not only said on the 18th, a week before, he asked for an outcome by the 25th, bearing in mind that the 27th was the due date. He also said, just determine this on the papers expeditiously, so we don't have to take up the Commission's time and I know what I need to do. So I fully agree with you, Chair. It must be decided on the merits, but the fact that we've had to repeatedly move mountains to get that determination, and even in circumstances when we ask for an earlier ruling, is the exact prejudice that my client relies upon. Thank you, Chair. I'm indebted.
Thank you. Subject to cogent explanations being given, I find some of the language gratuitous and at times both gratuitous and sensationalist. Let us look at paragraph 9.1 of the supplementary affidavit at page 54. There, Mr. Karim says, I'm reading the last 4 lines, part of the 4th, paragraph 9.1, I said, yes. And quote, it would be concerning in the extreme if it were willing, that is the Commission, to gamble with my life or my family's life to see whether the Commission's, underline this, kill rate would result in a, again, underline, hat trick. Close quote. I read this to mean that the Commission has killed, underline the Commission, has killed 2 people, and that Mr. Karim will be the 3rd person it kills if the Commission does not grant his application. That is how I read what I've just quoted. Now, Mr. Premier, what evidence does Mr. Karim have that the commission has killed 2 people?
Chair, may I say that I hear what the Commission says, and that's not how, with all due respect, I interpret that sentence, because before Chair started reading from, it would be concerning in the extreme. The sentence from about 5 lines from the bottom starts with, the Commission has already experienced 2 such incidences. So with all due respect, when it's spoken about the Commission's, and I say 2 such incidences, taking the correction that Commissioner Khumalo has made already, I'm just reading out what's there. So how I read it is not that the Commission killed anybody, but that the Commission has experienced, in Mr. Karim's version, subject to the correction, that 2 witnesses that came before it were killed, and that he's saying that the Commission's kill rate, in the sense of the number of witnesses that they've experienced having been killed, would result in a hat trick, and that he doesn't want to wait and see that happening. But that said, I take the admonition in the way that it is presented, and all I can do is apologize to the Commission if that indeed caused the offences both being gratuitous and sensationalist.
Thank you for...
That your client is going to appear before the commission is with a court application. That's the simple point I'm making.
Yes.
That's the simple point I'm making, as a matter of fact.
Yes.
Yes. That's all I wanted to accept.
I can give that fact because
Okay.
those are the facts. I can give
Okay.
the answer. What I'm trying to resist is the path we seem to be going down regarding the timing of the threat vis-a-vis the appearance here in front of the Commission and the absence of a threat vis-a-vis the application and the inference to be drawn potentially.
No, I'm not at inference stage
well, then,
yet.
then I have no concern.
I'm not there yet.
Then I have no concern.
I'm at fact-establishing stage.
Before we go there, potentially, yes.
Potentially. So we've established page 14 does not make any reference whatsoever. So this threat could, on this page alone, the reason for the threat could be anything. Could be his membership of the ANC,
Yes.
could be his business associations, in any of that,
Yes.
maybe even the commission.
Yes.
But we have no basis on
but-
page 14 to link it to the commission.
Yes, and well, no explicit basis to do so, but
No basis at all. What I'm suggesting is there's no basis at all.
No, that's where I need to resist that conclusion with all due respect, because
Yes.
by the same token that you put up 2 other possible explanations,
Yes.
his membership of the ANC and or his business interest, why is the commission and the timing of the commission seemingly discarded, but
No,
2
I've included
alternatives
the commission. I've said to you, it may be the
Yeah, okay.
commission.
Well, then-
but I have no basis
Yeah.
to say it's one or the other.
So-
there are 3 possible bases from what I've put to you, I've proposed to you. There are 3 possible bases.
or more. We
for
don't
the-
know.
Absolutely.
Then we're ad idem. Thank you.
And then A2, we've agreed it says nothing about, it doesn't help anything, right?
That was the
Because-
attempted assassination.
Yeah, no, this is the death, in fact, of witness D, him being shot.
The one at page 15.
15, yes.
Yes, the apparent hit. Sorry.
Okay, so this has nothing to do with being a reason, providing a reason for your client to fear appearing before us.
Well, you've heard me on that already, and I've tried to read that in context for you, having regard to the other paragraphs in the affidavit where he gives an explanation regarding how he sees these things happening, which animate his fears. So, factually, I accept your correction of the record like I did earlier with Commissioner Khumalo, but with all due respect, I don't think that detracts from the underlying point, which is that even if he's misunderstood the correct facts regarding what happened in respect of this witness, that is nonetheless something that animates the fear, which triggers the in-camera. That takes us to a reasonableness assessment. But
yes.
So I think we're at idem.
It's up to us to look at these that is referring to finally determine whether that fear is reasonable or not.
Yes.
So it's not for him to say.
Yes.
Of this, then we must make a decision that favors him. We have to assess the reasonableness of his fear, and we can only assess it on the basis of what his on, right?
Yes,
For the
I
order
accept that.
36. Okay.
May I just say that, and I speak subject to correction,
Yes.
but the answering affidavit doesn't make these points about what could have animated my client's fears and says, oh, well, you know, you talked about two witnesses, but actually this is the correct factual position. And so in as much as obviously the commission needs to correct the record where there are mistakes and apply its mind to the issues as they are, the point that I would make is that the commission fails to correct that animation regarding the fear.
Yeah,
So-
but what are you saying? Okay, now that you're saying this, what are you saying we should do with that? Just because the commission doesn't deal with it in the way that you say they haven't, are you
Yeah.
saying it's not within our powers to determine on the basis of what he has placed before us? Because maybe let me suggest this to you. As I see it, is even if they had chosen, the evidence leaders had chosen not to answer, we still have to determine your application on the basis of the case you made.
Absolutely.
Yes.
But
so it's irrelevant. It must be relevant for purpose of my engagement with you. It's relevant for purpose of you replying to Ms. Hassim, but for purpose of my engagement with you, it's irrelevant that they didn't say what you're raising now. What's relevant is your answer to what I'm raising with you.
Yes, and may I just say that I have no difficulty regarding the proposition you put to me regarding what you need to do. Absolutely, I'm not disagreeing with that. All I'm highlighting is that even his mistaken approach regarding what animates his fear is not rebutted by the commission as a mistaken basis to animate the fear.
Okay.
So,
Mr. Premier, we have a few times said the evidence leaders are wrong in what they have said. So it doesn't take the matter any further for you to say, well, they are not saying it. As I say, you'll reply to her if she tries to make that point.
But I'm sorry, I think we're speaking slightly past each other, Commissioner,
Yes.
with all due respect. I'm not taking a pleading point in the sense that, oh, the answering affidavit doesn't put up a rebutting version, therefore on Plascon Evans. As the chair rightfully said, there are rules that apply in a court proceeding which do not apply in these proceedings.
Yes.
All I am saying, insofar as your assessment of reasonableness is concerned and what animates the fear, is that even if he was mistaken at the outset when the application was launched, the commission, who is in possession of the true facts and the full facts in a way that we are not necessarily in possession of, could have said under oath, here's some facts that you need to think about regarding animating your fear. And I'm not making the pleading point. What I'm saying is that I have reasonably or not reasonably adjusted my client's position regarding the in-camera. And so all I'm saying is that where the commission itself doesn't put up a version to